Under his second ground of appeal, Milošević argues that the trial chamber erroneously established certain facts by relying on evidence it had not admitted during the proceedings. The appeal chamber dismisses Milošević's argument concerning the trial chamber's reliance upon a NATO weather report and his unsubstantiated submission that the psychological state of the civilian population in Sarajevo could not have been established without having recourse to an expert in psychology. Milošević's arguments concerning the siege of Sarajevo are addressed under his fourth grounds of appeal. Milošević's second ground of appeal is therefore dismissed. Under his third ground of appeal, Milošević contends that the trial chamber failed to consider the evidence as a whole, and in particular that it ignored the evidence showing the military activity of the ABIH. The appeal chamber finds that Milošević fails to meet the standard of review on appeal and therefore dismisses this ground of appeal. Under his fourth ground of appeal, Milošević challenges the trial chamber's finding regarding the civilian status of the trams in Sarajevo. The appeal chamber notes that the trial chamber considered evidence showing that trams were not used for transportation of troops or military equipment. With the exception of the sniping incident of 27 February 1995, the trial chamber was satisfied that there was no military personnel present on the vehicles or in their vicinity at the time the incidents took place. With regard to the sniping incident of 27 February 1995, the trial chamber received conflicting evidence as to the presence of one soldier on the tram. The appeal chamber finds, however, that Milošević's assertion that the presence of one soldier converted the tram into a military target due to the fact that it was used for transportation of military is untenable. With respect to Milošević's argument regarding the siege, the appeal chamber considered that the trial chamber only used the term siege as a means of describing the factual situation before it, referring to the conditions in which the population of Sarajevo was trapped throughout the indictment period and did not ascribe to it any legal qualification. Accordingly, the appeal chamber finds that Milošević fails to demonstrate that the trial chamber committed any error of law or of fact. The remainder of Milošević's argument concerning this issue are also dismissed. Milošević's submission regarding his absence from Sarajevo are discussed under his 12th ground of appeal. His fourth ground of appeal is dismissed in all other respects. Since Milošević's fifth ground of appeal relates to the sentence imposed by the trial chamber, it will be addressed at the end of the summary in the part relevant to sentencing. Under his sixth ground of appeal, Milošević argues that the trial chamber erred in fact in finding that Vojničko polje, Alipažino polje, Dobrinja, Sedrenik, Haražnika, and Marin Chor were civilian areas within the city of Sarajevo. The appeal chamber has concluded that despite the somewhat confusing language used by the trial chamber, it correctly engaged in a case-by-case analysis of the targets and modalities of the attacks, and not that of status of zones. The appeal chamber is satisfied that the trial chamber correctly established that the population of these neighborhoods of Sarajevo had civilian status at the time of the attacks targeting it. Consequently, Milošević's sixth ground of appeal is dismissed in its entirety. Under his seventh ground of appeal, Milošević alleges that the trial chamber erroneously found that SRK members were behind specific sniper fire. The appeal chamber finds that concerning the sniping of Jasmina Tabakovic, Sanela Dedovic, Dervija Selmanovic, Tarik Junic, and Adnan Kazapovic, Milošević failed to show any error in the trial chamber's reliance on the evidence on the record. Milošević also fails to show any error in the trial chamber's findings that trams were deliberately targeted by SRK snipers. Likewise, as regards Nermin Divovic and Jenana Sokolovic, the appeal chamber finds that the trial chamber fully considered and weighed all the relevant evidence, and that Milošević has failed to demonstrate any discernible error in its reasoning. Milošević's seventh ground of appeal is therefore dismissed in its entirety. Under his eighth ground of appeal, Milošević challenges the trial chamber's finding that the SRK was behind certain shelling incidents. Concerning the shelling of the Livaniška Street on 8 November 1994, the appeal chamber finds that Milošević fails to show that the trial chamber's conclusions were erroneous. As to the shelling of the Bashkarcia flea market on 22nd December 1994, the appeal chamber notes that regarding the direction of the fire, the evidence clearly shows that both shells that exploded on 22nd December 1994 at the flea market were fired from southeast. However, concerning the origin of the fire, the record indicates that the testimony of witness W12 was the only evidence identifying it with precision as being Vidikovac. However, witness W12 based his conclusion solely on the sound of one shell being fired. Considering the location of the ABIH and SRK positions, both in the direction from which the shell was fired, the appeal chamber is of the view that an analysis of the charge, as explained in the Galić appeal judgment, could have determined the position where the shell was fired from with greater precision. The trial chamber failed to address the deficiencies in the relevant evidence and to articulate its reasons for dismissing other possible conclusions with respect to the origin of fire. The appeal chamber therefore finds that whereas the evidence on the record could lead a reasonable trial chamber to conclude that it was most likely that the shells that hit the flea market on 22nd December 1994 were fired from the SRK-held territory, it was insufficient to support such a conclusion beyond reasonable doubt. In light of the above, the appeal chamber grants Milošević eighth ground of appeal in part and overturns his conviction for the shelling incident of 22nd December 1994. The remainder of this ground of appeal is dismissed. Under his 9th, 10th, and 11th ground of appeal, Milošević challenges various findings made by the trial chamber in relation to the possession and use of the so-called modified air bombs. The appeal chamber finds that Milošević's general claim that ABIH possessed modified air bombs simply reiterates his arguments rejected by the trial chamber without showing any specific error in its conclusion. Moreover, the appeal chamber notes that the trial chamber considered the allegation that ABIH used this type of weapons during the conflict in examining each of the individual incidents. Consequently, even if Milošević's general allegation regarding the ABIH possession of the air bombs during the indictment period were shown to be true, it would have been without bearing on the conclusions with respect to their use in the specific incidents which he was convicted of. Concerning the trial chamber's finding with regard to the shelling incident of 28 June 1995, Milošević fails to show that no reasonable trier of fact could have found, on the basis of the evidence presented before the trial chamber, that the TV building was hit by a modified air bomb launched from the SRK-held territory. Similarly, in relation to the use of aerial bombs in explosions between 7 April and 23 August 1995, Milošević fails to demonstrate that the relevant findings of the trial chamber were erroneous. In light of the above, Milošević's 9th, 10th, and 11th grounds of appeal are dismissed. Under his 12th ground of appeal, Milošević challenges the trial chamber's finding that he ordered the attacks against civilians. The appeal chamber notes that the trial chamber did not analyze whether Milošević ordered every sniping or shelling incident, but rather concluded that those incidents could only take place if ordered by him in the framework of the campaign of terror. At the outset, the appeal chamber notes that the trial chamber held in its discussion of the widespread or systematic attack, I quote, "A campaign is a military strategy. It is not an ingredient of any of the charges in the indictment, be that terror, murder, or inhuman acts," unquote. The appeal chamber notes, however, that in other parts of the trial judgment, the trial chamber appears to hold Milošević responsible for planning and ordering a criminal campaign. The appeal chamber understands these references as illustrating that the crimes at stake formed a pattern comprised by the SRK military campaign in Sarajevo. Therefore, the expression campaign in the appeal judgment shall be understood as a descriptive term illustrating that the attacks against the civilian population in Sarajevo in the form of sniping and shelling were carried out as a pattern forming part of the military strategy in place. The appeal chamber notes that the trial chamber did not rely on any evidence that would identify a specific order issued by Milošević with respect to the campaign of shelling and sniping in Sarajevo as such. Rather, it relied on the nature of the campaign carried out in the context of the tight command to conclude that it could only, I quote, "having been carried out on Milošević's instructions and orders," unquote. However, the appeal chamber is not satisfied that the trial chamber established beyond reasonable doubt the existence of a positive act required for the actus reus of ordering, showing that Milošević instructed his troops to perform a campaign of sniping and shelling of civilian population in Sarajevo as a whole.